Hello, hello. How are you doing? Welcome to Lawyers Infohub. It's a pleasure to have you on this platform. I thank you, my returning subscribers, for your consistency in following this channel. For those who are watching us for the first time, this is Lawyers Infohub. It's a platform where we share legal tips aimed at helping you to become a better advocate, a better lawyer, a better law student. We share legal concepts in the most simplified way for ease of understanding. So join me today as we go into a beautiful class. So today we're looking at Anton Pillar orders or Anton Pillar injunction. Yes. So what are Anton Pillar orders? Now, Anton Pillar orders is an order that is gotten from the court, and the essence of the order is for the to allow the applicant to enter into the premises of a respondent to search, seize, and detain possessions of the what respondent. What I'm trying to explain to you is that this particular order is mostly used in copyright, intellectual property situations. For example, where someone is complaining that his product has been adulterated, or people are selling the fake, or people have mass produced a fake of what the product is and they are selling it, or is in circulation, or someone is distributing, an exact replica of a product of a person, the works of a person without permission, without authorization, thereby ripping off the original owner of the work. This hap- this happens both in literal works, in film works. People go about stealing others' work and selling them or reproducing them without consent. So what this order would do is to help the owner of the work to apply to the court to say, give me the order to go into the property or the premises of this person, search the place, seize whatever which is the material evidence I need for this case, the case I will do to show that this person is actually, infringing on my right, on my copyright, intellectual property right. So this order is made what ex parte, because you can't go and serve the respondent and coming to the house to or the premises to catch, especially, or get the evidence you need. So it's made ex parte without being on notice. The normal way you do your motion ex parte, you do an affidavit where you now state the fact that you own this brand or you own this work and it's been registered, and that you're aware, or you've been notified that someone is reproducing this work without your consent and selling them, or you're aware that some retailers in social market, they're selling the fake of your work, and thereby stopping you from making the right earnings you're supposed to make. You have to also state the address of the premises you're going to, how you got your information, and the fact that you want to go and get evidence of what you're saying. Then a written address, the court will grant such an application. But there are principles that must be met before the court will grant. So the court has to be very careful, because it's not like going into somebody's house without permission to go start searching, ransacking the place, you know. So the court is always mindful when they grant Antarpilla or others, because actually the person making the application is saying someone is ripping off my sweat, someone is benefiting from what he or she didn't, build. This happens even in the film industry, where people reproduce, people that sell a lot of, even manufacturing company. People still go replicate other people's products and make them lose sales. Now, this particular originated, from a case known as Anton Pillar KG against Manufacturing Processes Limited. Is a 1976 case. It's from this case that the name Anton Pillar was given to that order. So it was the case that bettered this order. Is a chancery. Is a 1976 one England report 779. Yes, chancery 55. So basically, the idea behind this Anton Pillar orders, just like I told you, that was also raised in that case, is to deal with situations caused by what infringement of patents, trademarks, copyright, acts of piracy, which has always become, it has been a big blow in the business sector. Now, bringing this case to the Nigerian jurisprudence or to the Nigerian legal space, um, the courts will look at certain prerequisites. The court will look at certain before they go ahead to grant anyone who is seeking who is seeking to, you know, get this order because it can be abused. Yes. You have to also understand that Anton Pillar order has a hybrid character. It is not a penal action, but the disobedience of the order can lead to punitive measure. If where the order is obtained and the person with the security officers goes to this place and they are being restricted or not allowed to enter, then there will be a what punitive, you know, um, effect on the person who has resisted that, because it's more like it's a contempt of the court, and because there's a valid order which you're not allowing them to, make do with. So it's a civil remedy that is being enforced as a at a personal consequence. It's very important, because it gives power for unlawful entry and illegal search. It gives power. That's how people say it. It gives power for unlawful entry and illegal search of a person's premises through a spurious consent. You know, what this is just saying is that on a normal day, if the application for an autoplay is made on notice, then they are giving notice to the person who is defaulting to move away those going, but it's with the order of the court. A lot of people have the view that it shouldn't be ex parte. It shouldn't be ex parte, except in cases of extreme urgency. There's possibility of damage being, the possibility of damage being an adequate remedy, maybe it's ruled out or something, damages. All that is represented under injunction. But basically, for Anton-Pillar orders to be granted, the court will look at four main things. One, there must be a strong prima facie case of a civil cause of action. Is there a prima facie case of civil cause of action? Or someone just wakes up in the morning to say, I feel Mr. B is replicating my work and I need to go there. So there must be a strong prima facie case of a civil cause of action. There should be a civil cause of action, yes. Then the court will also look at the danger to the applicant or the plaintiff. So if the court will look at the danger to this person is very serious, this person is exposed to so much danger, he's not going to reap from his sweat. If the order is sought to what forestall the destruction of premises, they might go ahead to dispose or cut away all those evidence that will nail them uh, to 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 the issue on ground of infringement. So the court will look at the danger to the applicant. Now, the risk of also the removal of the evidence must be a good deal, more than merely possible. So the court will look at, if this thing is not done, they can move this thing, faking your products, there's an infringement of your trademark and all of that. So another important thing, the court also consider the reason to believe that it is possible that even if the respondent is, an order of injunction is granted against the respondent, you know, the possibility of what um maintaining status quo, but the preservation of the evidence. What? So the court will weigh it like, okay, it's better I grant this anti-pillar order so that these people can go in and bring in this true evidence. So, and because when the raid is done and the evidence is obtained, this person cannot deny it. The court also consider the harm likely to be caused by the execution of the anti-pillar order to the respondent, and his business affair must not be excessive. The court also look at, okay, once this order, if I grant this order and it is carried out, will it cause excessive harm to the respondent? So the court will wait. As much as I want to help, I want to safeguard this thing the applicant is asking me to do. what is the effect on the respondent and his business. So the effect, the harm should not be what excessive, not go there and someone dies, not go there and something goes out of hand. So the court also consider all of those to understand the legitimate object of the order. So it must be in sight for the judge before he grants the order. Court looks at, is there a strong prima facie civil case? If the order is not granted, the destruction of the evidence is crucial. The removal of the evidence is also very crucial. The likelihood that the respondent will disobey injunction, even if it's granted, court will look at it. The court also look at the harm that because of the respondent and his business, whether it will not be excessive. So they also look at section 22 of the Copyright Act, which gives you the right, to enter into the premises of someone you feel is causing a breach and all of that. This is similar to this the order you're getting in Anton Pillar. Many people have the view that that is different. That section 22 cannot make the court grant the application. So the court must weigh the options. The court will look at these principles. Are they in? Is this granting this Anton Pillar? Is it the best option at this point? So court looks at all this before granting an application of Anton Pillar. So and I've also told you that it's a made ex parte, not made on notice, like a motion ex parte, supported with an affidavit and a written address. You file it in court, and when the court grants it, with the order of court, can take security officers to the place and execute the order. And when you get that evidence, it's going to help your civil case. Yes, it's going to help you. It's going to help your civil case because it is what getting that evidence will do for you to solidify your case against the respondent. So, friends, entrepreneur order is it takes effect and it takes place all the time. But many people who are maybe are not into the IP sector may not understand it, or they just read it, they've not experienced it, or they've not seen it work. It does work. And although not in all circumstances they called grant and unpopular application, but all these, if these factors are in there, the court will look at it and say, well, I think it's the best option granting it. So, friends, I just hope you've learned something on unpopular order, what the court looks at in granting it, how it is prepared, or how it is drafted, is a motion ex parte, supported with a written affidavit and a written address. And the court looks at various options in granting it. And I also mentioned the name of the case wherein the name Antopila was originated. We formed the basis for all the Nigerian cases that has touched on Anton Pillar. I just hope you learned something today. If you have your question, please drop them on the comment section. We will answer them. We have other videos on the channel that is very educative, that will help you in your career, that will help you as a lawyer, that will help you as a law student. We have done several legal concepts. Just go through them, feed your mind, and you'll be glad that you're a part of this channel. Thank you, and do stay safe.